Hello and good evening. My name is Umar Khushal Khan and my SRN number is 2211430. Today, the topic of discussion is employment law in a global context. To further understand this, I would like to move towards my second slide. So, what is employment law? Employment law is the area of law that governs employer and employee relationship. Almost all businesses use some sort of employment law nowadays. For employees, these laws work to promote health and safety, to prevent discrimination, to establish a minimum level for economic support, and to prevent work disruption due to disputes between labor and management. The United Kingdom has a sophisticated set of employment laws that have been developed over the years. However, there is much inequality in practice when it comes to the realization of worker rights. The country ranks 39th on the 2021 Global Rights Index. Some important pieces of legislation that need to be mentioned over here in the United Kingdom are the Health and Safety at Work Act 1974, the Employment Rights Act 1996, the National Minimum Wage Act 1998, and the Equality Act 2010. So what does employment law cover generally? Well, there are a range of issues that employment law covers, which can be age discrimination, bullying and harassment, disability, discrimination based on race, religion, sexuality, or gender, dismissal and employee grievances, employment contracts, equal pay, holiday pay, minimum wage, parental leave, redundancy, working hours, and many other. So, how are employee rights determined? Well, they are determined by employment statuses, and there are three statuses in the United Kingdom, which are employee, worker, and those who are self-employed. Now, it would also be important to identify what employment contracts are. So, employment contracts are written agreements between an employer and an employee stating terms and conditions of the individual's job role. These contracts are open-ended, they can be terminated on notice, and they need not be in writing and may partly be in writing and partly oral. However, the basic terms of the employment must be confirmed to the employee in writing. Now, moving on towards to this third slide, it is essential to note the relevance of International Labour Organization whenever we're talking about employment law. So the ILO is a UN agency whose mandate is to advance social justice and promote decent work by setting international labor standards. The ILO was established in 1919. There are two decision-making bodies present in the ILO. One is the World Parliament of Labour, and the second is the governing bodies. Now, coming over towards the basic goals of the ILO. It is to create opportunities, respecting and legally protecting rights, building and expanding social rights, and promoting the social dialogue. The ILO has 8 fundamental conventions, and those are the Freedom of Association and Protection of the Rights to Organize Convention 1948, the Rights to Organize and Collective Bargaining Convention 1949, the Forced Labor Convention 1930, the Abolition of Forced Labor Convention 1957, the Minimum Age Convention 1957, the Minimum Age Convention 1973, Worst Forms of Child Labor Convention 1999, the Equal Remuneration Convention 1951, and the Discrimination Convention 1958. Respecting these conventions is viewed as a precondition for the application of all remaining ILO norms. Now moving on to the fourth slide. So the UK has contributed quite a lot to the ILO. So how has it contributed? Well, it has worked towards the development of laws and regulations, and the UK and ILO have common interests, which are promoting social justice, respecting international labor standards, and reducing extreme poverty. So the cooperation priorities in order for the development are strengthening global peace, strengthening resilience and response to crisis, promoting global prosperity, and tackling extreme poverty. Now, I would also like to mention the policies mentioned herein. The ILO has been helping its constituents develop national employment policies, also referred to as the NEPs. Now, after COVID-19 crisis, the NEP's implementation has become an even more important point. The guidelines suggest that three pillars for NEP's implementation need to be there. The first pillar is the interinstitutional coordination structures that bring all stakeholders on board in the NEP's process. In particular, an inter-ministerial coordination committee, also known as IMCC. The second pillar is an accountability framework that ensures stakeholders buy-in and endorses their role as key NEPs implementers, which is composed of commitments, result-based implementations, and oversight. The third pillar is a support system that includes institutions for policy delivery, information system, financing, legislative and regulatory systems. Now, the guidelines can be adopted to country circumstances and modified in the face of economic shocks, sudden conflicts, disasters, social unrest, or public health emergencies such as the COVID-19 crisis. Moving on towards the fifth slide. Now, the main legal question for this topic is, why are health and safety standards at work essential? So, this is a topic that does not have a lot of emphasis, and many people, many academics do not give it much priority. But what I am willing to do is have a debate regarding the importance of health and safety in any institution, in any department, in any employment contract, or around the globe, essentially. So, health and safety affects employer and employee relationships. There is a need to understand our responsibilities towards health and safety in workplace when navigating employee issues. The primary piece of legislation for health and safety laws are the Health and Safety at Work Act 1974, and therein are mentioned duties to protect health and safety and welfare. So there are three basic employment rights for a worker in health and safety. Now these rights are the right to know, the right to participate, and the right to refuse unsafe work. Dismissal for refusal to work in an unsafe environment would be unlawful under health and safety rather than employment law. Now, the UK's legislation on health and safety is also the HASAWA 1974, the Health and Safety at Work Act 1974. So, how has health and safety changed after Brexit? Well, from a health and safety perspective, most of the retained legislation is around chemical regulations. So things like REACH, which is the registration, evaluation, authorization, and restriction of chemicals, the CLP, the classification, labeling, and packaging of substances and chemicals, and the PIC, prior informed consent. Biocides, pesticides, and plant protection products, these are mainly the products that require health and safety. So now, in order to discuss this internationally, I would like to move towards my sixth slide. So, the Occupational Safety and Health Administration in the United States of America. It is also known as OSHA. Now, the OSHA administers the Occupational Safety and Health Act. The safety and health conditions in most private industries are regulated by OSHA. Nearly every employee in the nation comes under OSHA's jurisdiction, with some exceptions such as miners, some transportation workers, many public employees, and some of those who are self-employed. Now, for miners, there's another act present, which is the mines. Now, the administration is the Mine Safety and Health Administration, and it administers the Mine Safety and Health Act of 1977, which protects the safety and health of workers employed in the nation's mines. Another act would be the Fair Labor Standards Act, the FLSA. Now, the FLSA contains rules concerning the employment of young workers, those under the age of 18, and is administered and enforced by the Department of Labor's Wage and Hour Division. And there are some other resources present as well, which are the Office of Workers' Compensation Programs, some administrations which govern and regulate the occupational safety and health in the United States of America. So it is quite an important law in the USA. Now, coming over towards Pakistan's approach on health and safety. So this is present on slide number 7. There is no independent legislation on health and safety in Pakistan. The main law which governs this area is basically the Factories Act of 1934. And in the Factories Act, the Chapter 3 contains various safety arrangements which are to be arranged in the workplace areas. Now, there needs to be cleanliness, there need not be any overcrowding, some bright lighting needs to be available in order for the workers to work in a safe environment. Now, proper drinking water needs to be available, latrines and urinals, spittoons, welfare officers need to be present, and the age requirements are also mentioned in the Factories Act 1934. Coming over towards the 8th slide, what is the role of the government in all of these laws, and how has the government worked to implement it? Well, it is the government's role is to ensure that the provisions are followed. So how do they ensure this? They ensure this by appointing qualified individuals, by providing education regarding the workplace area and the work itself, and by providing proper training. This can be a point of debate whether or not the governments around the globe have ensured that these laws are followed, but it is quite relevant. Recently, a case in Islamabad was also is also worth mentioning, that there was a wildfire or a fire broke out in the mall of Centaurus, and it is something that awakens the thought of whether or not there were any preventive methods or precautions present at that time when such hazardous incidents occur. So these laws are very important in those essence. Now, I would like to mention a case law at the end of my my presentation. So the case law would be regarding Kennedy versus Cordia Services LLP 2016. The case facts are that there was a home carer who slipped on an icy path when visiting a client. So she took legal action against her employer, claiming breach of health and safety regulations and breach of the rules requiring employers to provide employees with protective equipment in certain circumstances. Health and safety regulations require employers to carry out suitable and sufficient risk management and risk assessment. The protective equipment regulation requires them to provide employees with protective equipment such as helmets, such as proper shoes, any sort of gear that might help them in the workplace. The employer had carried out 2 risk assessments, including assessing the risk of home carers slipping on snow and ice in the course of their employment. However, it had taken no action despite knowing, because of previous incidents, that ice was a general issue for carers visiting clients, and despite the fact the icy spell at the time of the incident had already lasted several weeks. These factors, coupled with the fact that shoe attachments were both effective and affordable and could have prevented the incident, meant that the employer had breached health and safety regulations. My recommendation and conclusion to this topic would be that employers should ensure they have carried out sufficient and suitable risk assessments, considered and provided clothing or equipment that may reduce any risks identified, and given employee appropriate training, even if the risks are shared by employees with members of the general public and are not materially increased by the nature of their employment. Thank you.